All right, so we have one last presentation for you today. So Amanda Johnston from Gardner Law joins us again, this time joined by Anne Miller from Medtronic. Just an FYI, there are no slides for this presentation, so we're just going to jump into introductions. Anne is a senior principal legal counsel at Medtronic, where she's a member of the Enterprise Legal Regulatory Team. Her practice focuses on FDA regulatory requirements, and she advises the company on quality system issues, FDA inspections, and responses to 483s and warning letters. Amanda, we've already introduced you earlier today, so I'm going to hand things off to you to kick off this final session.
All right, great. Thanks, Mary. And thanks, Anne, for joining us. Really appreciate the time. And we'll have a little bit of a coffee chat today to talk a little bit about FDA. The title of the program is FDA Enforcement Action, I think, discussion. But so in FDA's eyes, recalls, 483s, warning letters, they're not necessarily enforcement actions, but they do feel like enforcement actions when you're on the receiving end. So just wanted to clarify that, but yeah, we'll get into a little discussion, and feel free to jump in if you have any comments to Anne or redirect questions. So you have extensive experience working with FDA, working at FDA. What are just some high level kind of best practices, tips when a company is interacting with FDA on one of these, not necessarily enforcement activities, but like a recall, a 483, a warning letter, anything where they're asking you for information and you're having to react?
Sure. So I think there are three important things. The first one that I'll mention is transparency. When you're speaking with FDA, whether it's in a meeting discussing a recent recall, or you're writing to FDA responding to a 483, which for those who maybe aren't familiar, that's when FDA does an inspection of your facility and they find issues, that's the report that you get. So it's basically saying, here are the things that we think are problematic, and you have 15 days to respond to that. Be transparent, present the facts, state what you know. I know it seems obvious, but state what you know, and then also be clear about what you're still looking into. If you're still investigating something, be clear about that. You don't want to give FDA the impression that the status of an issue is something other than what it is. So be really clear about that, and be clear about what you know at the time. The last thing you want to do is give FDA the false impression about what the current status of the situation is. And FDA knows that issues evolve and that your understanding of issues can change over time. So don't assume that because you are being transparent about something that you're locked into that forever. Just be really clear about what you know and what you don't know. Now, that said, it doesn't mean you air all of your dirty laundry and make all kinds of admissions when you're having these conversations. It's a balance, but this is also where lawyers for companies or outside counsel can really help advise on words and strategies. So if you are advising a client, for instance, on some of these communications, you can help them strike the balance of being clear and transparent, but not saying too much and making some unnecessary admissions too early in the process. The second thing, and I'm seeing this a lot more, clear patient focus. FDA's role is to protect the public health, and they take that role very seriously. So when you're discussing with an issue with the FDA, even if it's a technical issue about a manufacturing process design, and you're maybe into some of the engineering, or you're considering about things coming down the road, some challenges that are going to be presented to the company because of the action you might be taking. Always keep in mind the patient when you're communicating with FDA, whether it's in writing or in a meeting.
Sure.
Consider the perspective of the patient, because that's often where FDA's mind is. How would the patient benefit from what you're talking about? What mitigations are you taking to reduce risk? FDA's questions and approaches when communicating with you are often driven by patient safety and reducing risk. And the last thing, I think that some people forget about this, and having been on the inside of the agency for a few years, it's important to understand at where FDA's motivations are and their challenges. So when you're meeting with FDA, you sometimes think that it's their big issue. It's one of the most important things they're thinking about. You are not their only stakeholder. You are one of thousands. They regulate everyone, and they actually try to do a pretty even job as best they can, even though sometimes, you may think that what they're doing is unreasonable or unfair. Remember that they're regulating other companies, and they have information about other decisions that you don't have. They also have a lot of external stakeholders that are making demands on their priorities and their interests as well, including the Department of Health and Human Services. The FDA is within that department. They can sometimes influence or set agendas for FDA. The White House, Congress, the typical Washington influences are there. And then also we're seeing this more recently, investigative journalists. They're investigating FDA decisions. They're publishing articles that, have a slant sometimes about FDA decisions. And I think that can, not motivate FDA, but they're certainly keeping that in mind when they're making decisions about how often and how kind of openly they're communicating publicly about certain things. And then just with all of this, if you're advising a client or working with a client, or if you're working in-house, even if it's just a run-of-the-mill 43, or if it does escalate to something like a warning letter and you are having periodic meetings, for instance, with FDA. If you're in-house, it's okay to join those meetings. I think there's a misconception sometimes that if you bring a lawyer to a meeting, especially if it's in my role, I'm a regulatory lawyer, so it's kind of what I do. I haven't found in my experience that joining a call or being introduced as in-house counsel for the company escalates the conversation. So, it is a balance, but I think it's okay to be at the table. You hear things differently sometimes, and you can also, advise the client a little bit better when you're hearing things firsthand.
Yeah, absolutely. Have you ever had a situation where you joined the call and then FDA said, "Oh, wait, do we need to get our lawyer involved?" Or I'm just curious if that's ever happened.
Never.
Okay.
Yeah, never. Now, I'm not saying it, there might be some situations where that would happen, but I do think there would be a difference perhaps if you brought your outside counsel.
Yeah.
That may send a message, but I've never had that happen in my experience.
Okay, great. So yeah, we talked a little bit kind of about what you keep in mind when you're responding or have a situation where you're responding to an FDA action. When you have, this is kind of a clarifying question, but when you get like a 483, for example, what does the response process look like? Is it, who's writing it? Is it, because typically quality would see that as kind of their job to respond, but is it a team approach? Is it quality and then legal, or how do you kind of work through those responses? Or what would you suggest, I guess?
Yeah, so I think that, depends on the company. I'm sure there are companies where quality has always done it, or regulatory, and that's what they continue to do. I do a lot of the work. I think the process is typically, getting involved early on so that you can understand what the finding is really about, because sometimes what's on the paper isn't necessarily clear, what the underlying issue is. So get involved early. Ask a lot of questions. You might have to do some coaching, I guess, about don't defend this. I mean, you try to defend it in the inspection, so now is not the time to push back. My experience is that doesn't work well. So you kind of work with them on how to structure the response so that you're presenting the facts, maybe presenting some context about what happened, but helping them then develop some meaningful actions to respond.
Right. Okay.
writing. So taking the content that they give and then putting it together. in a
Right.
response.
Got it. Okay, thank you. And kind of on the topic of 43s, with COVID over the last, almost 2 years now, we've seen kind of a pause on in-person inspections. And now it sounds like they have resumed based on risk areas and industry. Do you have any thoughts or comments on kind of how inspections are going, or, what have you seen, or what kind of trends do you see coming in the future?
Sure. Well, FDA, I saw kind of a brief uptick last spring when vaccines were rolling out and the rates were kind of dropping, kind of late spring. There was a little bit of a ramp up in inspections, but with the Delta variant, it's pulled back quite a bit. So they're still operating under their risk-based approach, where they'll look at the rates in a particular area. And if it's at a certain level, they won't inspect unless it's mission critical, as they call it. So that's still out there. I think that they still are doing some on-site inspections. The biggest thing that I think we'll see as we move out of this latest surge and hopefully not into another one, is that FDA will pursue a risk-based approach. I mean, they have to. They have a backlog, so they're going to prioritize. And if it's a mission critical, how they term it, COVID related, usually they will continue to do those inspections. But we're also seeing follow-up inspections to Class 1 recalls prioritized. Okay. So if your company has a recent Class 1 recall and FDA has not done a follow-up inspection, I would expect that you might be on a short list. So just be prepared for that. And these are, a particular interest for lawyers, because the Class 1 recall itself can raise legal issues, whether it's a threat of litigation or government inquiries. And then you tack on the inspection, which has the potential of disclosing underlying issues related to your quality system. So I would really focus on those and making sure you're prepared. I think the other thing we're seeing is that because of kind of previous changes to, especially the Center for Devices, they're more expert. They're focusing pharma inspections are pharma investigators and device investigators. So they're more specialized and they're more technically smart than maybe in previous years. So the inspections are a little bit more rigorous. And I think that trend will continue. I think also as they get through the backlog, you might see them a little bit shorter and focused. So they're going to go in and they're just going to hit their things, and they might, you might get a 43 and then they're going to move on. And I think that with that expertise, they also are better at looking more broadly across the quality system too. So if they identify an issue in one part, like let's say there's if it's a recall inspection, they may start looking at your manufacturing or whether there was a design issue or a development issue, and then they're going to carry that thread all the way across and find multiple issues for something that feels, at least to you, like it's just one thing. Right.
Yeah. So more focused and probably more efficient from their perspective. Are you seeing any alternative methods for inspection? I know there was some talk about kind of virtual inspections. Has that gone anywhere? Have you see any trends coming that could?
Yeah, there was some talk about that last winter. I think when we were sort of in the depths of COVID and trying to talk about ways to do remote inspections. In the device area, there are notified bodies, the European model to have the notified bodies do the inspections. They've done a really good job of jumping into remote inspections. They use Zoom, they use SharePoints. So they were able to do some coverage throughout COVID when FDA was not. FDA consistently said that they don't have regulatory authority to do remote inspections. So I don't see that changing. I think we've probably past that point where it felt like an urgent need to do something more of an alternative approach. they, at least the CDRH side, they did start a pilot for remote inspections. And I haven't heard anything about that since it started. So I don't know how that's going or whether that got any legs.
Right.
So I think that, again, it'll just depend on where the rates are. I would anticipate that the thing we'll see mostly is on-site, more targeted focused on-site inspections versus spending their time trying to develop a new program.
Right. And probably shorter inspection periods. I mean, rather than having them visit for weeks at a time.
Yeah, I think so.
Yeah.
I think so. I mean, I think if there are, you know, as the inspections start, we may start to see some warning letters
Sure.
too that follow some of these.
Yeah.
And, you know, then the follow-up inspections, I think if there are concerns about, you know, a company already under warning letter, they're going to probably stay as long as they think they need to. But generally speaking, the initial coverage, I think they'll be more focused.
Okay. What about routine QSIT audits? Are those kind of gone for now, or are they just going to be focusing on issues, risk-based?
That's what I'm seeing, unless they tack it on.
Sure.
So if they are doing a for-cause inspection, for instance, following a recall, they may do some QSIT work there,
Sure.
especially if that site is overdue, if they haven't had a full QSIT or
Right.
level 2 or level 1 for a while.
Okay. Interesting. So we've talked a little bit about recalls. I'm just curious. I think we've seen a little bit of an uptick in class 1 recalls. So, you know, some potentially could have been a class 2, but were, you know, classified by FDA as class 1. Do you see that as a trend, or do you have any comments or observations on that?
Yeah, well, we're definitely seeing that in the device space. I'd say over the past 6 months, where we're seeing more class 1 recalls, many of them with no or very few adverse events involved. So I think that there are a couple of things behind that, but one is that FDA is integrating more medical and technical input into recall decisions. I mean, this is a kind of a function of the reorganization that they did in the device side. That they have medical review looking very strictly at the patient impact. And so with that, they're looking at risk more strictly. And, you know, the theme that I'm seeing is they're not waiting for a patient impact to be realized before classifying something as a class 1 if there's a potential for patient harm. So if you're taking a recall and the severity of risk is high, FDA may classify it as a class 1, even if the rate of occurrence is very low. They'll assess the potential and not wait for the harm to actually occur before considering it a class 1. Now, I want to be careful not to suggest that the recall decisions that need to be made should be made. Sure. And, you know, you might anticipate that you know, if there is a patient harm involved, that just be prepared that something that may have been classified as a class 2, maybe a year or 2 ago, may ramp up to a class 1. The other thing that we are seeing, or I'm seeing, is this concept of residual risk. So I think there's a factor when, you know, you reduce the risk in the marketplace. So how much residual risk is left after you take the field action or take the recall. So for instance, if you initiate a recall and you send a Dear Doctor letter, HCP letter, but don't remove the device, there's FDA may view that as some risk left in the marketplace. Yeah. Or if you implement a change to a product and you do a rolling change going forward, but you decide not to replace. All of that goes into FDA's decision about how much risk is associated collectively with the recall you're taking. Okay.
Yeah, some parallels with like the Aleer case that Mark and Dulcie mentioned earlier, and the St. Jude case, where they had an issue, took a recall, but then it ended up being prosecuted under the False Claims Act. So Is there any changes that companies should be making when they're thinking about whether they need to take recall action just because of the kind of more conservative stance? But if a company is deciding, is this a recall, are there any kind of trends or considerations that you would recommend?
Yeah, I mean, I think the similar considerations apply, right? The notion of risk and how much risk. So you should assess, again, patient risk, be real honest with yourself and challenge yourself about whether or not there's patient risk. Things like the recall isn't needed because the patient risk is mitigated because it's something that, let's say it's something used in a surgical procedure, the physician will notice. They'll notice the problem, and so they won't use the device.
Yeah.
Or the user, if it's a patient use home use, the patient will see it. Or, well, if this happens, they can't use it, so they won't hurt themselves. Or, we can replace it right away, or they can call for help. All of those things where you're sort of putting the quality control,
exactly,
on the user. Those FDA doesn't look kindly on those types of decisions. So you have to really think about, again, the patient focus piece that we talked about earlier. Put yourself in the patient's shoes and the user's shoes. What would they expect to see? What would they want to see? And what kind of the human factors involved with, especially, again, I'm qualifying this, I'm on the device side. It's very different for pharma, but
right.
Yeah. So, and if you make the decision not to, again, when the inspections do come around, they're better, they're smarter. If you've made a decision not to take an action, if it does end up on a 43, that's an unfortunate issue to have to deal with later.
Right. Exactly. Okay. And you mentioned the reorganization of CDRH and kind of how they've now consolidated their pre-market, post-market. They're looking at the whole product life cycle, which makes sense. Have you seen or do you have any observations on the pre-market side when it comes to change supplements or device changes?
Yeah, I think that definitely. I mean, we think about the, sort of the medical expertise, the pre-market lens from FDA on the post-market side when they're looking at recalls. But I've seen the flip of that too, where during, let's say, a pre-market review session, there might be input from the compliance side. So what the Center for Devices did a few years ago was they reorged. They used to have pre-market, ODE, they called it Office of Device Evaluation, divided by types of devices. And then they had this big Office of Compliance, and Office of Compliance worked all across. Well, now they've blown up the Office of Compliance, and you have compliance experts, so kind of post-market inspection experts that are tied in with the different products. So the offices have a compliance function within each product family. So what we're seeing then is more integration with compliance questions and the regulatory pre-market side. So if, for instance, you're reviewing a submission, you might get questions about, let's say it's a change to your product, it's a design change. And you might get questions about whether you plan to notify users. So it's like something that's going to reduce risk. What's your recall strategy? Are you going to replace what's already out there or rolling change? You might get questions about complaint rates. What do you expect for the complaint rate? Do you expect it to go down after you replace this device? Questions about specific MDRs that FDA has seen. So you might see your pre-market folks who are on those calls might receive those questions. And I think it's just important to know that that's a possibility and to not get blindsided by those. Seek input within your organization before you talk to them. In some companies, like the quality and regulatory sides, those different functions, which we sort of have historically divided as pre and post-market, they may be different. In a smaller company, they may be integrated, so you're always talking, but in a larger organization, you might not necessarily share information. And I think going forward, it's really important that your quality and regulatory kind of are almost lockstep when it comes to these things, that your quality folks know what submissions are going in and what they're saying, and that conversely, you don't want a submission to go into FDA that makes a clear statement about what your complaint rate is, your adverse event rate is, and then it's wrong.
Right.
And the data was right there all along. If, so you can imagine, it seems obvious, but you can imagine how those issues could come up, especially in a larger organization. So
Yeah.
I would say align yourself like FDA is as much as you can, because that's how they are looking at things. And it's important that regulated industry do the same thing.
Yeah. No, that's a really good point. I mean, being in regulatory at a large organization previously, I could see easily how it could get siloed. But yeah, like design changes, anything related to field actions or recalls or MDRs, or the reason for the change is important. So that's good advice.
Right. And I would extend that to even to 43s.
Yeah.
We talked about kind of sometimes if the lawyer gets involved and writes, you want to make sure that you've got all of your stakeholders, if the 43 is big enough, involved, so that you're really challenging yourself about the commitments, demonstrating a commitment to fixing the issues, helping you write specific, clear responses. And then also, sometimes I think that other organizations can bring a balance in tone, because it's another thing to really be mindful of when you're communicating, especially in writing, is to watch your tone. Don't be defensive. And also sometimes watch the advocacy. It's not necessarily the right time to be an advocate. I know that's difficult for lawyers. But my approach is to use factual and balanced, and almost, actually, I've been told my writing is dispassionate, which I took as a compliment.
Yeah. Yes, exactly. Sometimes that's good.
In this context, it is.
Yes, exactly. Well, good. Well, we are at time. So, Anne, I want to thank you so much for your time today. Really appreciate it. I think you provided some great insights for everybody watching. Mary?
Yes, thank you so much. Just a few housekeeping items for cleaning up. First and foremost, thank you to all the presenters today. We so appreciate your time and insight and staying on schedule. That was probably the most on schedule CLE I've ever participated in. Second, these slides will be available, as well as the CLE information for those who want credit. They'll be emailed out to those who registered a few days from now. Again, if you have any questions that didn't get answered today or want more information, you're welcome to reach out to Dulcie Foster or Mark Gardner, and their information is at the beginning of the presentation on those slides that will be emailed out. Otherwise, our one last ask, do complete our program evaluation. It helps us put on programming and CLEs that you actually want to spend 4 hours watching. So take a few minutes, click the link provided, and otherwise we thank you for your time. Have a great day.